Good morning, everybody. Hello and welcome to Your Trust, Your Pet, and Your Legacy. So thank you very much for joining us today. My name is Mia Dunn, and I am the Director of Philanthropy at Pasadena Humane, where planned giving is one of my responsibilities. Today's webinar will cover several planned giving topics, including the reason why most of you are here, the importance of pet trusts. During the webinar, you can use the chat function to type in questions, and we will have about a 10-minute Q&A session following the presentation today. Before I introduce our presenter, I would like to take this opportunity to note that if you decide to name Pasadena Humane in your will or trust, or as a beneficiary of a life insurance policy, IRA, 401k, or another vehicle, you will become part of our 1903 Society of Planned Giving Donors, and we offer special benefits to these members, including our pet guardianship program. And you can also choose to direct your gift toward a particular program or simply to where it's most needed. So if this is something that you would like to talk more about, I invite you to contact me, and my information will be made available at the end of this presentation. Now it gives me great pleasure to introduce our presenter, William Hayes of the Hayes Law Firm in South Pasadena. Bill moved to Los Angeles from Chicago as a young child, and shortly after adopted his first dog, a brindle boxer named Duke. Bill is a graduate of the UCLA School of Law, where he was the senior editor of the UCLA Law Review, excuse me. He has also served as Associate Editor-in-Chief of the National Law Journal and was a participant in the Moot Court Honors Program. He is a contributing author to several books on estate planning, on estate planning, and has written several syndicated newspaper columns on the subject. Bill is the founder of the Hayes Law Firm in South Pasadena, which specializes in estate planning and probate law. Prior to that, he also practiced entertainment law for a number of years. He is a member of the California State Bar, the Los Angeles County Bar Association, the American Academy of Estate Planning Attorneys, and the Estate Planning Council of the San Gabriel Valley, among other groups. And if that wasn't enough, outside of the practice of law, Bill is a man of many talents. He plays flute, creates stained glass, and has practiced martial arts for the past 20 years and has achieved his black belt. So without further ado, here is Bill Hayes, and thank you, Bill.
Thank you, Mia. Thank you very much. And I'd like to thank everybody for attending our webinar today. We're going to break the webinar down into three parts. First, we're going to talk about the essentials of estate planning, what the particular needs may be of you and your family with regard to how your estate is managed and distributed upon your passing. Secondly, we will talk about pet giving, pet trust giving, and how do we deal with the maintenance and care for our pets if we should become disabled or upon our passing. And lastly, we'll talk about charitable giving. This is a good time to talk about estate planning because these are perilous times in our country. I mean, there's a lot of uncertainty. People are not sure as to what the future may hold. Good reason for that. 15 million lawsuits are filed in our country every year, and of course that compounds year after year. Approximately 1 million Americans had to file bankruptcy each year. In the year 2020, the national average for a one-year stay in a nursing home, private room, was $105,850. Over 60 million Americans give aid and attendance to family members and friends, and countless lawsuits are filed in our courts all the time as a result of defective wills and trusts. And lastly, this is an honor not to be proud of, but America has the third highest divorce rate in the world. It used to be that we had the highest divorce rate in the world, but we were beaten out of that honor by the Maldives Islands and Belarus. So go figure. And we cannot forget the very real threat of the coronavirus. That and other global health issues are looming over our heads all the time. Now, 66% of all bankruptcies in our country are caused by medical bills. And health insurance is not going to be something that prevents you from having to file bankruptcy, because 75% of those people who filed for bankruptcy had health insurance, and still had to file for bankruptcy. Mia has given you a little bit about my background, so I won't dwell on that, but I will point out that my firm has consistently received 5-star ratings on Google and Facebook and Yelp, and we've received honors as being one of the best firms in the area for probate and estate planning. And we have been cited as an estate planning resource by most of the major media. My office has been located in South Pasadena for over 22 years in the historic Behringer Studios building, which is at the corner of Mission Street and Orange Grove in South Pasadena. It's a beautiful building with great garden courtyard, and I hope that you'll appreciate it as much as I do when you come to visit us. So, as we go through this presentation today, I would ask that you keep an open mind about what we'll be talking about here. And I would hope that you will not treat this as merely an educational exercise, because what I'm going to talk about here has applications certainly for you and for most of us. And you need to look at how you would handle the situations that we'll present if it were to happen in your life. We're going to profile a typical couple here today, Bill and Mary Jones. Bill and Mary have an estate worth about $700,000, including their home. Bill is now retiring, and of course, as retired people, people who are retiring do, he has plans for how they're going to handle that retirement. Now, though we're talking about a married couple, most everything that I say here will have application for you, and you'll be able to easily discern where it does not apply. Bill and Mary have 2 children. There's John. Well, John is the problem child. There's always someone in the extended family who has that issue, right? And then there's Susan. Susan is the dependable child. Now, mom and dad can always depend on Susan when there's a need. Bill and Mary have all types of planning options. One, they can spend everything. You know, you all have heard that guy who says, listen, I made this money so those kids can go out and make their own money, right? I once saw a bumper sticker at driving through Hollywood, which I think summed up that philosophy perfectly. It just said, no dime left behind. Well, that's a planning strategy. You can also die intestate. To die intestate means that you've done no planning whatsoever. To die testate means that you've planned. Or you can put everything into joint tenancy. Oftentimes people will come to me and say, you know, Bill, I'm not so sure I need all of this estate planning. And I think I'm just going to put my daughter or my son's name on my house and on my financial accounts. And that's my plan. And my response to that is always the same. Well, I would think twice about doing that if I were you, because if you put your child's name on your assets, and though that child be a responsible person, well, we all know that bad things can happen to responsible people too. So if you were to put your son or your daughter's name on your assets and they were to become involved in an accident or have a tax issue or bankruptcy or divorce or whatever problem comes into their lives, that is now a problem for your assets. And if they are sued, your assets are going to be considered their assets as well. The other problem with putting your children's names on the property is that you will cause them a capital gains tax problem. So if you bought a property, say in 1980, and you paid $100,000 for it, and you put your child's name on the property in the year 2021, and the property's worth $1 million, well, they're going to have to pay capital gains tax on the appreciated value of that property at the time that they should choose to sell it. So that's probably not the best thing for you to do. So it is much better for you to leave the asset to the child in a testamentary fashion. And by that, I mean by will or trust. Or you can also, many people will think, well, I have a simple estate. And I know, after having heard that many times in life, that when people say that they have a simple estate, what they really mean is that they have an average estate. Because really what I have seen over the years is that we all have the same stuff. You know, it may be a question of value, And one person may have 2 houses versus 1 house, but most people who come in for estate planning will have a home, they'll have bank accounts, they may have a retirement plan and an insurance policy. That's pretty much everybody. So when people talk about simple estate planning, usually they're saying it in the context of saying, just give me a will, something simple to handle all of this. And when they say that they want a will, I always have to explain to them what that really will mean for them. Because if you have a will, it will require, when you have a will, it's required that you have to go through the probate court process. And if you have to go through the probate court process, it's going to complicate the lives of your family a great deal, not to mention the cost that will be incurred as a result of having to do that. So you don't really get out easily by just creating a simple will. It's simple and inexpensive for the moment, but very expensive later on. Sometimes people will just say, well, you know, I can just go get a form. And they're quite right. You can, if you're of a mind, you can go on the internet. There are forms that you can get on the internet for trust. But of course, the old refrain, you get what you pay for. And if you feel comfortable just using a form to take care of everything that you spent your lifetime creating, well, that's probably not the best way to think of planning. Sometimes people will tell me, you know, I saw this ad in the newspaper and they sell trust for $500. Well, I says, well, why would you pay $500? Cut out the middleman and just go to Staples and get the forms. You don't want to just get something simple if you're talking about planning for everything that you have. What we do in our office is create something called the Family Wealth Trust, and I'll talk to you about that a bit more as we go forward. So with our couple, Bill has a stroke. Though he had plans for his retirement, sometimes the best laid plans just don't work out. As a result of that stroke, Bill may encounter long-term care expenses, and long-term care expenses can come in the form of in-home care, adult day care, assisted living, or a stay in a nursing home. Genworth is an insurance company, which is one of the leading providers of long-term care insurance in the country. And every year they put out a survey of the annual cost of care, both nationally, state, and in the counties around the country. But for the state of California, these are the average cost for these types of cares. Now, homemakers services costing $66,000, assisted living $60,000, a stay in a nursing home in California. The average, you know, to have a private room is $137,240. How many of us can really afford that? Not many. And remember, these costs go up an average of 3 to 4% every year. So how do you pay for long-term care expenses? Well, one, you have to use your own money until you don't have any more money left. Your health insurance does not pay for your long-term care needs. Your health insurance pays for doctor's visits and short hospital stays. Long-term care, chronic, ongoing physical or mental needs are covered by long-term care insurance. And if you don't have long-term care insurance, you're going to have to be responsible for that payment yourself. So if you have long-term care insurance, I certainly applaud you. That's a good thing to have, though I know it can be expensive, and I know that not everybody will qualify for it. And to complicate the matters even more, the number of companies offering long-term care insurance is starting to decrease rapidly over the last few years because of the cost to the companies of having to maintain that care. So if you can get it, great, but not many people do have it, and I understand that. Medicare. I think generally in some way people, as they grow older, will think, well, surely Medicare has a plan for taking care of our long-term care needs. Well, if you think that, you're right and you're wrong. You're right in that Medicare will take care of your needs for up to a maximum of 100 days. And that's after you jumped over some pretty high hurdles to qualify for that. So, but it's after 100 days, Medicare will no longer take care of your long-term care needs. So you're back to your having to take care of those needs. If you were a veteran and you served at least one day during wartime, you will be eligible for various benefits through the VA. So if you are unable to pay for your care out of your pocket, and if you don't have long-term care insurance, and if you know that Medicare is of limited duration and you didn't serve as a veteran during wartime, you're only left with one answer as to how your long-term care needs will be met, and that's Medicaid. Medicaid is known as Medi-Cal in the state of California, and you qualify for Medicaid/Medi-Cal by meeting a certain asset standard. So going back to our couple, as a result of his stroke, Bill is now disabled and unable to handle his affairs. He's considered basically incompetent to handle himself at this point. This leaves Mary in a bind, because Mary, of course, not having expected this to happen in their lives as they grow older, now has to figure out how she's going to pay for the needs of her household and she and Bill's personal needs, as well as paying for Bill's rehabilitation costs. So she has to figure out how can she use the assets that she has, that she and Bill have, to handle these needs. Well, one of the biggest assets that they created during their lives was an IRA that Bill had through his employer. And they contributed to this IRA faithfully for many years. So Mary goes to the IRA administrator and says, you know, my husband and I have this IRA with you, and we'd like to liquidate that IRA because we have certain needs to be met. And she gets a surprise, because what the IRA administrator will say to Mary is, Mary, I'm so sorry to have to tell you this, but you cannot liquidate this IRA. And of course, she's taken aback. What do you mean I can't liquidate the IRA? You know, this is something that my husband and I created over many years, and I need it now. And the IRA administrator will say to her, yes, your name is on the IRA, but you're on the IRA as a beneficiary and not the owner. Your husband is the owner, and without his signature, we cannot liquidate the IRA. And that's, you know, very exasperating for Mary. She's not sure what to do. So she thinks about the other significant asset that they have, which is the home that they've had for many years. Bill and Mary bought this home in joint tenancy, which means that the home is owned by them together, but upon the death of one of them, the surviving spouse will then be the owner of the property. So Mary goes to a realtor and says, you know, we've had this home for many years. My children have moved out. I need this asset to take care of my husband. I want to sell the house. And unfortunately, Mary gets another surprise. The realtor tells her, you know, Mrs. Jones, I'm so sorry to have to tell you this, but you can't sell the home. And of course, again, Mary is just dumbfounded. What do you mean I can't sell the home? This is my home. I own it with my husband. And the realtor says to her, that's exactly the problem. You own the home with your husband. And if your husband is unable to sign documents, you cannot sell this home. Mary's in a total state of confusion as to what to do. Well, the only other option that Mary has at this point is conservatorship. She would have to go to court and be appointed the conservator of her husband. Conservatorship is a legal proceeding that applies to adults who are either mentally and or physically disabled or incompetent. I can tell you from having witnessed conservatorship proceedings many times, it is a nightmare for the person involved. It's humiliating. The court is thereafter in control of your life. It's time consuming. All of your personal information is disclosed, and all of the costs of the conservatorship come out of your assets. And when you have a conservatorship, there are going to be a minimum of 2 attorneys charging at an hourly rate against your assets, and sometimes 3. And of course, that's in addition to the court costs and bonds and all the other fees that come with a conservatorship. Now, Bill has had his stroke. He was incompetent. Mary may have gotten the conservatorship, but ultimately he dies. Now, Bill and Mary just had a will that they have prepared to cover their estate. But a will does not avoid the probate court. In fact, what a will does is guarantee that you must go through probate proceedings. So Bill's estate will have to go through all of the costs and delays and public exposure that entails. Probate proceedings where someone has died really revolve around settling disputes between parties, making sure that creditors are paid. You want to make sure that all the assets are marshaled so that the court will know what the deceased person had. And it's about changing title to those assets and ultimately distributing the assets to the beneficiaries of the estate. If you have to go through a probate court proceeding, it's going to be very expensive. In fact, that's where most attorneys who do estate planning make most of their money, because the attorney gets a percentage of the gross value of your estate. And I emphasize gross because it doesn't matter what liens you may have against the property or mortgages or whatever is still unpaid. It's the gross value on which the attorney's fee is based. And I won't go through the particulars here, but it's a sliding scale based on the amount of the assets in the estate. The attorney is paid a percentage of the gross value, and whoever is named as the administrator or executor of that estate is paid the same percentage of the estate. And in addition to that, the attorney and the administrator are entitled to hourly rate payments for all types of other services. Everything comes out of this estate. That's what happens when people have a will or they do no planning at all. In fact, the only people who are in probate court when someone dies are those people who have planned poorly because they just used a will, or they've done no planning at all. If you go through the probate proceeding, it's going to be very time consuming. The most simple probate estates these days would take you 9 to 12 months to close. And of course, if there are any difficulties, it can take up to years to close. It's open to the public. Anybody who wants to know what is in your probate estate only has to go down to the court. There's a big file room on the first floor of the Superior Court downtown on Hill Street. And they can look, pull your file, see what you have, who's going to get it, and approximately when. That's a problem because Los Angeles has often been referred to as the scam capital of the country. And when you have something like that, this type of proceeding, it makes it very easy for people who have ill intent to do the wrong things with regard to somebody who's vulnerable. If you have assets in other states, you'll have to have separate probates in each state, separate attorneys, separate administrators, and so forth. So having a will, not doing any planning at all, not a good thing. So after Bill's death, Mary lives, let's say, another 10 years. She may develop her own ailments. Let's say that for Mary, she develops Alzheimer's. She's placed into a nursing home. Most people who wind up in nursing home don't stay there long. It's usually an average of about 2.3 years before people die in nursing homes. So Mary's unable to handle her own affairs. Her responsible daughter, Susan, steps up. Susan goes through mom's belongings and she finds a power of attorney for her mother. Mary had the foresight to do some planning after she saw what happened with Bill. So she had a power of attorney prepared, naming Susan as her power of attorney agent. So Susan locates these legal documents, and she has the wisdom to take it to an attorney who specializes in elder law. And that elder law attorney says that, you know, Susan, we can protect most of your mother's assets if the power of attorney that she created has appropriate language in it for us to do the things that we need to do. Unfortunately, the power of attorney that Mary had did not have that language in it. It may be that she found the form somewhere and decided to take that to a notary, and she felt that was sufficient. But what this does not allow Susan to do is to do any estate planning that she would need to do to protect mom's assets. Most estate plans fail, one, because people just use forms. And as I say, you know, you can, if you're just going to get a form, go on the internet, they're free. Also, plans fail because people have not planned for what happens as they age. What do you do as you age to deal with the things that come with aging, the health challenges that come with aging? The US Department of Health and Human Services says that 7 out of 10 people over the age of 65 will wind up having long-term care health problems. And 40% of that number will wind up having to stay in a nursing home. So have you really planned, is your estate plan sufficient if you have not dealt for what is probable in your life as you grow older? And that's 7 out of 10 people, 70% of people over the age of 65. That makes it probable that you will have a health issue. And if you're fortunate not to, great. But is it wise to not have at least planned for what you will do so that you do not lose everything that you have because of an unexpected medical catastrophe? Oftentimes too, estate plans fail because the estate plans have not been properly funded. That is one of the problems that occurs with buying forms or buying things through the internet, because there are a lot of other steps that have to be taken that rely on you to take them personally. And that's where the purchase of the most inexpensive form of planning fails. Because the reality is, and I've seen this many times, people who have bought forms, and I won't go into naming these different services, but who have bought these forms, but they don't feel comfortable in transferring their assets into their estate plans. And as a result, the assets are outside of their estate plans, which means that the trust won't have any impact for those assets. So funding has to be done properly. Plans also fail because there's no remarriage protection to make sure that in the event of a remarriage by a surviving spouse, that the assets are not lost to the family. There's plans fail also because there's insufficient protection for the heirs in the event of their divorces or the difficulties that they have in their lives with regard to money and other issues. And plans fail because there's nobody around to keep people apprised of changes in the law. The laws do change, everyone. I'm a member of the estate and trust section of the state bar, and we get notices from the state bar of these different changes which affect people's estate plans. But if nobody is telling you about this, you don't know this. So that's a failure with estate plans, if nobody's keeping you up to date. There must be a better alternative, and of course I've been alluding to it throughout this presentation, and that is the use of a trust. You want to create an estate plan that includes a trust. When you talk about an estate plan, really what you're talking about is a number of documents which are meant to plan for your well-being and your family's well-being and protect your assets. That would be the trust, which is a revocable document. You can change it or amend it at any point in time. You're in charge of your own trust until you are unable to be in charge or upon your death. Then there's a document called a pour-over will. It's called a pour-over will because it's really acts as a safety net. so that if you forget to have titled an asset in the name of your trust, your representative can go into court and say, Your Honor, it was the intention of my client that this asset not go through the probate court proceeding, and we'd like to pour it over into the trust. Then you have powers of attorney. You will have powers of attorney for your financial affairs, and there you will name somebody who will sign your checks and sign agreements on your behalf when you're unable to do so for yourself. And you'll want to have that kind of power of attorney to make sure that someone is authorized to sign those checks and make sure your utility bills continue to be paid and the mortgage continues to be paid and so forth. Because as we all know, creditors are notoriously unsympathetic to your being sick. So you'll want to have that handled. You'll want a power of attorney also for your health affairs. You'll want to name a person who will act as your representative in dealings with hospitals and doctors. And you'll want medical authorizations to make sure that your family members or other representatives can receive copies of your medical records if they have concerns about the treatment that you've received as part of your care. And if you are a married person, we create community property agreements to make sure that you are able to exclude certain taxes from being applied to your capital assets. So that is how an estate plan works. You will have all of those moving parts as a part of the plan. So this time, let's give Bill and Mary a quick do-over. This time assuming, rather than a will, that they have a properly done trust in place. Bill has that stroke, but remember, even with the estate plans, you can buy forms, but estate plans are not commodities like a bag of sugar or a Ford that you buy at a car dealership. Usually you're looking for at those assets in terms of price, but because they don't differ really. But with estate plans, they widely differ. Now that Mary has the trust in place, she can control all of the assets that Bill and she have without the involvement of the court system. So she can control those assets. She won't have to go hat in hand to the IRA administrator begging for money to take care of the needs of her husband and herself. Nor will she have to have any concerns about selling the house, because she'll have complete control to do that. And after Bill dies, Ralph, her next door neighbor, who may have, he had a wife, and in this example, Ralph's wife also died, and he may decide that he wants to start dating Mary. So, but Ralph lost all of his money because of poor planning, and all of the money that was already that he and his wife had were used to pay for his wife's care, and now he has no money. So if he decides to start dating Mary and perhaps he proposes marriage to her, well, the question is he coming for love or is he coming for money? Well, we want to make sure in the planning that we do for Mary and Bill that they have a plan of action which will prevent the assets from being lost to their family, to their children, so that if Mary were to marry Ralph and then Mary were to die, you want to make sure that Ralph does not wind up with the assets, thereby unintentionally disinheriting Bill and Mary's children. So we have a prenuptial provision that we put into the trust to prevent that. So Mary will be able to show Ralph, listen, Ralph, I'd love to marry you, but I can't commingle my assets with you because I have this agreement. And of course, Ralph is going to have to understand that. So, and if Mary should wind up with Alzheimer's, as she did in our earlier scenario, there won't be an issue of her having to have Susan go to court or anything like that, because she's already named Susan as her legal caregiver. There won't be any conservatorship proceedings for her. And neither Bill nor Mary's estates will have to go through any probate court proceedings. There won't be a need for death probate. We refer to conservatorships as living probate. And of course, when one dies, it's death probate. And by having a properly drawn estate plan, they avoid both of those processes. We also believe that it's very important that when you do your plan, that you not forget this very essential, important, but intangible gift that you can give to your family. And that is the family story. That is the gift that will keep on giving long after the money that you left to your family has gone. If you can tell the family story and pass that on to your children, your grandchildren, your great-grandchildren, to the extended family, that's the gift that will keep on giving and will be valued long after the money's gone. And when you do a proper estate plan, it should include a story like that so that you can preserve the family legacy. A well-drawn estate plan can include a number of different types of subtrust. So you may have a subtrust to deal with the issue of remarriage, like with Ralph coming by to court marry to make sure that assets are not lost. We may create a divorce protection subtrust for someone like Susan, though she's responsible as a young woman, she may be married to someone who is not. And if they should divorce, you don't want that in-law making a claim against her assets as community property. You can think in terms of retirement subtrust and how you can use retirement subtrust to extend the life of your retirement benefits for the benefit of your heirs. There are grandchildren subtrusts and special needs subtrusts for disabled people, or incentive subtrusts for people who are not living up to their potential, or spendthrift subtrusts for people who are irresponsible with money. And if you have blended families, you'll want to create a trust planning to make sure that the children from both families of the spouses are taken care of. And last but certainly not least, you need to make sure that your trust incorporates long-term care health planning. In our office, we practice a specialized area of estate planning known as elder law. And what elder law is about is making sure that as you age, you have a plan in place to make sure that you do not lose your assets if you should wind up having long-term care health problems. We create in your trust something that we refer to as Medicaid triggers. And that will be something that your representatives will be able to implement to protect your assets and then get you qualified to receive benefits for your care from the state. Now, pet planning. It's one of the subtrusts that we can create in your estate plan is a pet trust. In a survey conducted by Kelton Research, 81% of those surveyed consider their pets to be as equal family members with their children. The American Pet Products Association reports that only 9% of people with wills or trusts have made provisions for their pets. It's not so much for lack of caring, people just don't oftentimes seem to think of it. Unfortunately, when those pet owners become disabled or pass away, their pets often end up in crowded shelters or on the streets. In order for those pets, those loyal companions, to be cared for if you should become disabled or upon your passing, you have to pre-plan. You know, your pet is a part of your world, but to your pet, you are the whole world. And if you haven't provided for the care of your pets and you become disabled or die, who's going to care for those pets? When creating an estate plan for the care of your pets, there are 3 documents that most people think of. They think in terms of powers of attorneys, wills, or revocable trust. With regard to powers of attorney, you want to be able to provide your caregiver with copies of those types of documents. If your pet is to be relocated out of the area, you certainly want to make sure that your planning includes travel arrangements and the care and maintenance for the pets. Your intended caregiver would not only be caring for your pet, they'll also be handling the money that you will leave for the maintenance of the pet's care. And if you're worried about long-term care disability, making you unable to care for your pet, consider naming that person as your power of attorney. But remember this, powers of attorney terminate upon death. They are only valid during a period of disability. And when you die, they are no longer valid. Wills is another option, as are pet trust. If you use a will, you can either use a will or trust to name an individual to care for your pets. You can also give them the ability to name who you might want as a pet caregiver. Now, a trust is much better for your pet than a will. One of the major drawbacks in using a will for a pet care is that wills will require that you have to go through a probate court proceeding before any of the monies are available for the pet. And that can take months, it can take years. Obviously, your pet does not have that long a time to spare in terms of surviving. So the use of a will for pet care is not a good choice. The monies will not be readily available. Now, if you, on the other hand, decide to use a trust, the use of planning through a trust will make the money immediately available for your pet, so that there is no lapse of time with regard to ensuring that the pet is cared for. In the state of California, pets are considered personal property. They are property like the refrigerator in your home is property. You cannot make your pet your direct heir. And since you can't leave money directly to your pet, it is best that you set up a trust to govern how monies will be set up and who will be in charge of the monies to care for that pet. If you do that, you will want to consider creating a budget for the care of the pet, which might encompass a plan for feeding habits and veterinarian information and medical conditions, toys and favorite activities, and whatever their special quirks are. Because whoever you name as your pet caregiver does not know your pet like you do. And if you are going to really do a good job of caring for your pet, you'll want to make sure that these things are incorporated into your planning. If you have a social media account, as many people do, you may want to make sure that the new pet caregiver has access to that account. Don't assume that just because someone says that they will take care of your pet, you probably want to make sure that you really vet them on this issue, because it's one thing to cavalierly say, yes, I'll take care of your dog or cat, but it's quite another to have to commit to doing that over years. So make sure that that person is really committed to taking care of your pet companion. Now, when you leave money for the care of a pet, sometimes people may not do the right thing. You may have left a certain amount of money to be used for the care of the pet, and over time, the person who is that pet caregiver, if they're not really committed to the pet, may not use the money in the right way. So you may want to consider naming a pet trust enforcer. I know that name is a little over the top, but someone who can be an advisor to make sure that the monies are used in the proper way so that they can oversee how the expenditures are going for the pet. And if there are any monies remaining in the trust once your pet passes, you can stipulate that the balance is donated to a pet supporting charity such as Pasadena Humane. There are 5 primary methods of plan giving. 1, you can give the monies directly to Pasadena Humane in your in your estate plan. Secondly, you might want to consider gift annuities that will name Pasadena Humane. You can also name them as a beneficiary on your life insurance policies or your retirement accounts. It may be that you have assets that you would like to contribute, such as real estate or vehicles or boats, planes, those kinds of assets that can be liquidated and also used for the benefit of taking care of the pets in our community. The point is, you know that Pasadena Humane Society has been here for quite a long time and will be here for the future to take care of pets like yours that don't have anyone else to care for them. So consider Pasadena Humane as a worthy beneficiary of your estate plan. Remember your own pet in your plan giving, but also support Pasadena Humane's ongoing efforts to bring aid and comfort to pets everywhere. Thank you very much for listening.
Well, thank you, Bill. That was certainly a comprehensive overview of this very important topic. We have some time left, so we'd like to open the floor to questions. Feel free to type in your question in the chat box. I think we have a couple questions there already. And if we don't get to your question, or if you think of something later, you're always welcome to contact us, email or phone call. I think there's a slide with our information on it that'll be coming up shortly. And also after this webinar, we will be sending out a brief survey, and we hope that you will take a moment to complete it. And thank you so much again for spending part of your morning with us and learning about this important topic. And so questions?
Okay, it looks like a few questions came in here. I'm not sure if you guys can see it on your end, but I'll just read them out. The first one is from Gabrielle. Do you recommend establishing one trust per pet, or can multiple pets be covered by one trust?
Multiple pets can be covered by one trust.
Okay, next question is, so with a trust, do you need to change ownership of IRAs?
No, you can have the well, it depends on what you want to do. If you can have the IRA paid to your trust, or it can be paid to a named designated beneficiary otherwise. But whomever you name as the beneficiary is where the IRA money will go.
Okay, great. And the next question is for Mia. Mia, can you please explain the pet guardianship program?
Sure. As Bill noted in his presentation, we encourage people to name a guardian and at least one contingent caretaker to ensure the continued well-being of any pets that they may leave behind. But we realize that this is not possible for everyone. Sometimes people have no family, or they just don't have anyone they can name. And so when you name Pasadena Humane as a beneficiary in your estate plan, you will become part of our 1903 society. And one of the benefits is the pet guardianship program. And that means that in this case, if you don't have anyone to take care of your pets, that we can step in and assist with the care and rehoming of them.
Okay, great, thank you. The next question is a power of attorney part of a trust?
A power of attorney is something used in connection with a trust. A power of attorney is a separate document, and with that power of attorney, you name someone who will act in your stead if you are physically or mentally unable to handle your own affairs. So if you decide to name your best friend as your power of attorney, they can do the same things that you could do if you designate that in your power of attorney. The powers of attorney sometimes have limited abilities in terms of what they will allow the person to do, and sometimes they are unlimited. The trust is something separate and apart from the power of attorney. There you will have trustees who will be in charge of the trust. You, of course, will be your own trustee initially, but if you should become disabled, then you will have people who step up to take your place while you're disabled. And we refer to those people as successor trustees. And the same thing, of course, happens upon your death. When you pass, the successor trustees take over. Okay.
Thank you, Bill. One more question for Mia. The 1903 Society, is it open to people who don't live in Pasadena?
Oh, absolutely. There's no geographical limits on it. The only qualification is that you would need to name Pasadena Humane as a beneficiary, either in your trust as a whole, or you can name us as a beneficiary of just a life insurance policy or an IRA or any other sort of vehicle. And if you do go to our website, pasadenahumane.org, you can go to the plan giving section, and which provides quite a comprehensive overview of all the different ways that you can leave a plan gift.
Okay, great. Thank you for that, Mia. Another question, this one's for Bill. My husband and I are fairly young, but we have a plan for our pets in the event that one or both of us become disabled or die. We do not have a pet trust yet, or do we not have a trust yet? We currently only have 2 senior dogs and plan on getting more pets as the years go on. How easily can trusts be updated to either exclude pets who have passed or add new pets?
You can always amend your trust at any point in time. What I often recommend is that people have a general provision for their pets. I mean, you can name your pet Fluffy if you wish, but I mean, you can also include a general provision that will take care of whatever pet you may have at the point of your passing or during your disability. And so if you set money aside for that purpose, and you've named somebody who's to be the caregiver, you can have it such that they are to be the provider for whatever pet you have at that point in time.
Great, thanks for that, Bill. You actually answered 2 questions with that answer. So moving on to the next one. Can you gift a commercial annuity rather than a charity annuity? What's the difference?
I'm not familiar with the commercial annuity.
Okay, so whoever asked that was an anonymous question. Happy to look into that further if you wish. There'll be a survey that goes out after the webinar, and you can feel free to use that to fill in any other questions that were not answered during this webinar. It looks like we've got a couple more questions here. Are trusts recorded at the time of death? How does family know there's a trust?
Trusts do not have to be recorded anywhere. In fact, in the last 30 years, I think I've only had one person ever record a trust. And you can record a trust with the county registrar recorder's office, but most people choose not to do that. Most trusts are kept private to the family. So yes, you will want to have some apparatus set up to advise family members of where your estate planning documents are. You can either tell them where the documents are. It may be that you have a home safe that you keep those documents in. I generally don't recommend a safe deposit box because people, unless you have those your representative's names on the box, it's going to be difficult for them to get into the box without a court order. But you want to have some place where you can have those people know that when the time is needed for them to have access, that they know where to go. In our office, we use a service that we pay for the first year with all of our clients that will allow these assets, this information to be accessed online. So if an emergency should come up for the person who created the trust, you will give your representatives, your loved ones, this information as to where they can go to get the information if such a situation arises for you.
Okay, this question is for Mia. I have a few life policies. I've been told to have a separate life policy just for charitable giving. So Pasadena Humane would be the only beneficiary on that policy. Is that the correct process?
That is a process that's not familiar to me. I can look into it some more, but what I can tell you is that if you do want to name Pasadena Humane as a beneficiary of a policy, you would just need to contact your broker and request the proper form. And you can indicate that the shelter could either be a full or a partial beneficiary of that particular policy. But as far as the multiple ones, I don't know, but I can look into that.
Okay, great, thanks. Okay, a couple more questions. Best backup trustee if you don't have a person who can do it. Wells Fargo Trust Department, corporate trustees, thoughts?
Yeah, most banks have, most of the large banks do have trust departments. Oftentimes the prices can vary actually. Sometimes they will have a price that is not so high because of course they are interested in investing the assets. And other times the prices are a bit higher, generally in the area of about 2% of the estate. Wells Fargo has such a department, Union Bank has such a department, credit unions like TIAA, CREF have such a department. Then there are private companies like Northern Trust or Whittier Trust. There are a lot of professional trust companies around, and there are professional fiduciaries around. There's an organization called the Professional Fiduciaries Association through which you can get individuals who are authorized to act as trustees for your trust.
Okay, great. Two more questions. I believe this person is asking, the question is, if a family member moves to a different state, does the trust still apply?
And the answer is yes. It does. The trust is valid in all 50 states. So the only thing that varies sometimes with your estate plan may be your healthcare power of attorney. There are some states that may have some requirement in them that other states may not. But other than that, the rest of the estate documents are going to be recognized no matter where you are.
Okay, great. All right, and this is the last question we have here for today. That's a two-part question. I think it's for you, Mia. If friendly cats are taken to Pasadena Humane, is that their forever home or do they get adopted out? What about ferals? Also, can the home that the cats are in be secured in a living trust for a finite period of time until rescue and or placement is found?
Well, I think as far as the home question goes, I think that would be better answered by Bill. But as far as the cats, through the pet guardianship program, we would assist in the care and rehoming of the cats if you do end up leaving them behind. We are trying to divert as many animals from coming into the shelter as possible. And so in a case like that, the animals may go to a foster home and be adopted from there once they're evaluated by our team. So because there's less stress on the animal if they are in a home environment versus the kennel. But certainly, if the cats are healthy and all that, we, will work to adopt them out as quickly as possible. Ferals, it's another story, and I don't want to answer that not having all the correct information, but I can certainly get back to you on that. If Brian, if you could let me know who answered that or asked that question.
Yeah, I wouldn't add anything to that, Brian. I think that's a fair response.
Okay.
I just wouldn't know how to answer about the home part of that question about putting the home in the trust.
Oh, I'm sorry. What was it about putting the home in the trust? I didn't quite hear that.
Yeah, it's the second part of that question. It says also, can the home the cats are in be secured as in a living trust for a finite period of time until rescue and or placement is found? Yes,
whatever terms you want in your trust can be put into the trust as long as they're legal. So if that's what you wanted to have happen, sure, that can be done.
Okay, great. And I know I said that was the last question. This is the final question because I know we're running out of time here. But Marilyn asked if she's a dual citizen in both Canada and the United States, does the trust work in both countries? Or does it require separate trust?
No, I would not say that the trust works in both countries because I don't know Canadian law. I only know that it works here, and there are certain restrictions on you as the creator of the trust if you do not have US citizenship. Because with most trusts in the United States, they will require that at least one trustee be a US citizen or that there be a US financial institution as a co-trustee or trustee of the trust. That's of course for matters of taxation and so forth.
Great, well, thank you guys. That wraps up all the questions.
Okay, and I just want to add that we will be sending out a recording of this webinar so that you can watch it again if you want to, if there's anything that you missed. And as you see on your screen, our contact information is up there. So for any other questions on plan giving, you can contact either Bill or myself. And if you would like to talk further about including Pasadena Humane in your own estate plan, then I'm always happy to talk on the phone or do a video, the Zoom thing. Very happy to. I want to thank you everybody once again for spending your morning with us, and I hope that you found the webinar useful and a lot of information. So, and thank you so much, Bill and Brian. We really appreciate it.
Thank you, Mia.
Okay, take care, everybody.